Good afternoon, everyone, and welcome to today's webinar, Judicial Trends in Public Health 2020, Year in Review, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Senior Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this webinar will be available on the Network's website shortly after the conclusion of today's event. We strongly encourage attendee participation and would love to hear from you, so feel free to submit questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send us your question. We'll be addressing them during the Q&A session of today's event. Your moderator for today's webinar is James G. Hodge, Jr. James is the Director of the Network's Western Region Office and the Peter Kiewit Foundation Professor of Law and the Director of the Center for Public Health Law and Policy at the Sandra Day O'Connor College of Law. He'll be leading us through the rest of today's webinar, so James, over to you.
Charles, thank you so much. Good morning from Phoenix, Arizona, where we're broadcasting, and good afternoon to others on the East Coast. We're delighted to be able to join you today for an incredible look back on 2020, year in review in relation to judicial trends in public health. I bring you greetings from my colleagues on the Eastern Region from the Maryland Carey School of Law at our Eastern Region office. You'll hear from them momentarily. I am here presenting from our ASU Sandra Day O'Connor College of Law in Phoenix, Arizona. We've got some great material for you from the East Coast, from the West Coast, and everywhere in between in regards to these critical judicial trends. When we talk about judicial trends during the course of our session today, we're referring to our regular monthly listserv that we produce through the Network for Public Health Law in collaboration with our Western Region colleagues and Eastern Region colleagues you'll hear from here momentarily. This is a monthly listserv. We'll also do blasts that go out regularly. Here's our edition from January, and what that specific judicial trends publication does is basically take you into all those critical cases that our attorneys across the network have identified and selected for specific trends in regards to how we're looking judicially in public health law and policy in the United States. What we've done over the last year to try to track that for 2020 was absolutely remarkable against the backdrop of one of the most sensational years in public health law, I think probably throughout our entire careers we'll ever see. So what this specific judicial trends does is it lays out for you in each edition 10 select cases, brief abstracts, brief assessments, gives you a real good sense of what some of those particular issues are. You can subscribe to the judicial trends through the network directly, and our next edition, of course, will be coming out on February 15th. We have a great document. If you don't know about it, it's on the network website as we speak. It's our archive of all of the cases and their brief synopses that we actually assessed 200-plus cases over the course of the last year. You can actually review that to get a strong sense of all the major trends that we actually have try to catalog in relation to critical topics, including things like the source and scope of public health legal powers, constitutional rights. You'll hear a lot more about that momentarily. Preventing and treating communicable conditions, social distancing measures, chronic conditions, injuries, and other specific harms, public health information management. We have cases on regulated communications, monitoring property and the built environment, and you bet we've got cases from this past year on public health emergencies, legal preparedness, and response. Now, with all of that said, the ability to actually assess these specific cases in real time is there for you. You can actually use our archive as you go forward as well for 2021 for the same purpose. Here's our game plan for today. This is what we've tried to do over the course of our time preparing for this specific webinar. Of those 200-plus cases that we selected for judicial trends, of which thousands were looked at for the purposes of assessing just those, we boiled it down to 16 pivotal cases we're going to go over today that mark trends from 2020 and carry us into the next year ahead in 2021. For each of these specific cases, and I'll briefly lay those out for you in a moment, we're going to talk about the facts, the issues. We'll give you the real skinny of what happened in the case, what's the major holding, and most importantly, what's the public health impact or potential impact of that specific decision. Now, you'll hear from 7 additional colleagues of mine across the Eastern and Western regions in just a moment I'll introduce. But we will then conclude that with a 1-minute lightning round designed to give you our best in regards to 2020 key judicial projections going forward. Your questions, your comments forthcoming will be a big part of our session too. Lay them out for us, as Charles noted, in the Q&A portion of the webinar as you see to the right of your screen. I'll be monitoring that very closely, making sure our presenters get a chance to hear as many questions as possible. Okay, without further ado, these are our 16 cases, 7 from the West Coast, 9 from the East Coast. Half of these cases, if you recognize the titles, are U.S. Supreme Court cases for good reason. This was the pivotal year for Supreme Court jurisprudence in public health law and policy. You'll see why here in just a few moments. But these cases below as well, additional ones in major lower courts at either the federal appellate level, state appellate level, or otherwise. And to that end, the subject matter of these cases, all over the gamut of what and how we actually think through public health law and policy. Issues related to gender identity, to vaccinations, to COVID-19 powers, to the Affordable Care Act, on the East Coast, right to vote issues, reproductive rights, workplace discrimination. We've got it all covered for you here today. And in doing so, let me try to give you a brief sort of presentation of who will be speaking with you momentarily, and then I'll just launch right into our first couple of cases before handing it over to one of our next presenters. All right, now, without further ado, I'm delighted to introduce my 3 Western Region colleagues, all of which will be presenting here momentarily. Linda Barraza is a fantastic senior consultant with our Western Region office, long-standing colleague and just one of our top persons working in so many different arenas as an associate professor at the Melanie Zuckerman College of Public Health at the University of Arizona. He was very well known nationally for multiple different fronts, including vaccination and maternal and child health. My great colleague, Jen Pye, senior attorney with us in the Western Region office, one of our research scholars here at ASU's Center for Public Health Law and Policy. You'll hear from Jen momentarily, much as you may have recently in the webinar through the network on vaccination policy in a COVID arena, which was fantastic. And then Sarah Weather will join us too, a senior consultant with our Western Region office, a fellow at the O'Neill Institute for National and Global Health Law at Georgetown University, one of our proud alums from ASU Law, and a fantastic MPH grad from the Johns Hopkins Bloomberg School of Public Health. Then, our Eastern Region colleagues will also be mixed in regards to our presentation. My fantastic colleague, Kathy Hope, Director of the Eastern Region Office, Professor at the University of Maryland, Carey School of Law, where she also directs the Legal Resource Center for Public Health Law and Policy. She will actually sort of end us with a great presentation on her 2 fantastic cases. You'll hear more from Kathy as we end in that particular portion. Carrie Lowry has joined us today, too. She's an adjunct professor at the University of Maryland, Carey School of Law. She's also Deputy Director of the Eastern Region Office, and I'm delighted Carrie will immediately follow me in just a moment. Matt Swinburne, Associate Director of the Eastern Region Office, Adjunct Professor at the University of Maryland School of Public Health and School of Pharmacy, has 2 really sensational cases to lay out for us. And then Brooke Torton, who is Senior Staff Attorney with the Eastern Region Office, Deputy Director of the same center Kathy is leading at the Legal Resource Center for Public Health Policy, will have an additional 2 great cases. All right, the game plan's been set. Let's jump right into it. I've got 2 great cases to mention to you. I'm going to be brief in doing so because we're going to get the ball rolling to make sure you get to hear all of these pivotal 16 cases from 2020 which make critical differences. This is the only case, California versus Texas, that I don't have a decision to announce because we're awaiting it in 2021. However, you know the prominence of this specific case. This is the huge next case in the Affordable Care Act sort of series of cases the U.S. Supreme Court has examined and will lead to potentially really catastrophic repercussions should the court go in a specific direction on this specific case. Now, we'll give you a bold sort of prediction about that in just a moment, but let's just be sure what we're talking about here for anybody who are not familiar as much with California versus Texas. The case originated in Texas. It originated with states like Texas and multiple other states, including Arizona, where I'm based right now, raising concerns about the individual mandate in that post-Tax Cuts and Jobs Act arena, of which then zeroed out the penalty for the mandate. Now, you know that whole scenario of what that may have led to, arguments that the individual mandate, a critical component of the Affordable Care Act, so critical as far as that third leg of the stool as far as upholding everything we're trying to do with the Affordable Care Act, implementation issues and access and otherwise. Once that mandate was zeroed out by the Tax Cuts and Jobs Act, says these states, that provision must be unconstitutional because it lacks any capacity under the tax power that the U.S. Supreme Court previously said would authorize the implementation of the individual mandate, notwithstanding a disallowance under the interstate commerce power. What's it all boil down to? Texas and other states were saying if that individual mandate goes, so must the rest of the Affordable Care Act. They were arguing, and successfully, at the district court level and in the Fifth Circuit in New Orleans, that if the individual mandate is unconstitutional, so must the rest of the act go as well. It's inseparable from a legal perspective. What we essentially mean by that is you can't separate the rest of the purposes of the act from that unconstitutional mandate. Consequently, it will go. That's the argument that arose in federal district court. That judge bought it. The Fifth Circuit did buy the issue related to the unconstitutionality of the mandate, but booted it back to the lower court for the purposes of assessing severability. Now, that's what got to the U.S. Supreme Court. A mutual decision to appeal directly to the Supreme Court on the status of the individual mandate. The court had its oral argument. It batted the issue back and forth. We don't know what specific decision may come out of the U.S. Supreme Court in 2021. What we do know is it could be sensational. If it were to invalidate the entire Affordable Care Act, that could be big trouble, obviously, on so many different fronts, from access to other specific arenas. Don't project it, though. I think what you're going to see out of the U.S. Supreme Court soon is even the potential to assess that individual mandate within specific realms, or potentially just view the rest of the Affordable Care Act as totally severable. We'll see. Grisham versus Reeb, a state Supreme Court case out of New Mexico, highly consistent with so many other decisions you're seeing across the nation in relation to COVID-19 preparedness and response efforts. What happened in New Mexico is what's been happening in so many places. Significant constitutional challenges to social distancing efforts made and implemented by state government in response to emergency declarations. In this case, Governor in New Mexico, Michelle Lujan Grisham, issues her emergency declaration, authorizes her Secretary of Health, Kathleen Kunkel, to do a variety of different things pursuant to their public health emergency law there, including closing businesses. Now, you know, nationally, that was a little unpopular and got furthermore as economic impacts started to be felt across states. Multiple businesses challenged the Secretary and Governor's authority to actually implement those closure measures, and also, on a pure administrative sort of basis, whether or not they could actually assess penalties against those specific measures. That got interesting fast because New Mexico's Public Health Emergency Response Act, or FERA, does not explicitly allow for the type of business closures that were implemented in the state. It was an interpretation of the breadth and authority given pursuant to that act that allowed the Secretary to issue those specific mandates. The New Mexico Supreme Court fully assessed this decision after some appeals and such, and to be sure, made it clear that these specific measures, business closures, were constitutionally sound, were authorized pursuant to the state's police powers, and could be backed up by civil penalty provisions. How does a case like this and what we may see forthcoming in 2021 make a big difference? Hey, expansive interpretations of public health emergency powers provide essential flexibility. You've got to have those as we saw throughout 2020 to be able to respond to COVID-19 in real time. Cases like this make it happen. Other decisions in other jurisdictions, less so. Now, without further ado, let's continue on with our assessment of these 16 top cases. I'm turning it over to my great colleague, Carrie Lowry, in the Eastern region to take a look at a critical right-to-vote case. Carrie, go for it.
Thank you, James. So the first case that I wanted to talk about today is the Republican National Committee versus Common Cause Rhode Island, which was decided by the U.S. Supreme Court in August. This case is essentially a voting rights case, and it concerned a provision in Rhode Island state law that requires two witnesses to sign any absentee ballot. Now, Rhode Island Governor Gina Raimondo had suspended this requirement for the presidential primary in June of 2020, and the ACLU and other interested parties brought a lawsuit to extend that suspension through the presidential election. The state actually agreed to drop the witness requirement via consent decree, which was ordered by the Rhode Island U.S. District Court in July, and Republicans appealed asking for a stay of that dissent decree, or essentially a suspension of the consent decree to bring back that witness requirement for absentee voters. In its decision, the Supreme Court agreed with the Rhode Island U.S. District Court and with the First Circuit that the witness requirement unconstitutionally burdens the right to vote during the COVID-19 pandemic. And in terms of public health impact of this case, aside from the obvious benefit of facilitating voting from home while minimizing contact with non-household members, there's powerful evidence in epidemiology that civic engagement matters and has a significant impact on population health for a number of complex and interrelated reasons, which we don't have time to get into today. But essentially, civic engagement means healthier communities. Next slide, please. So the next case I'm going to discuss is Brown versus Azar. We actually did not include this case in Judicial Trends because of the timing of it, but we did issue a News and Insights post on it that you can find on the network's website. So essentially, the CDC issued a temporary halt on residential evictions that went into effect on September 4th of 2020. And in Brown versus Azar, property owners sued to invalidate the order on a number of grounds and to prevent the CDC from enforcing the order. The court, the Northern District Court of Georgia, denied the preliminary injunction and affirmed CDC's authority to issue the order. That's a really critical part of that decision. The court allowed it to stand as, quote, an effective public health measure that prevents the spread of communicable diseases. Now, in terms of the public health impact of a case like this, and I should note that this case has been appealed to the 11th Circuit, and there is some question, right, about whether there's a mootness issue here, but it has been appealed to the 11th Circuit. Upon my last check this morning, there hasn't been an update. But in terms of impact, because the court upheld the authority of the CDC to act so broadly to contain communicable disease, there are obvious implications for future efforts to protect public health in this and other public health emergencies. And I think it'll be really interesting to see this play out. More specifically, it's difficult to overstate the impact of preventing disruptive displacement from people's homes, particularly during an epidemic, but all the time. Preventing evictions allows compliance with stay-at-home and social distancing directives that have been put in place by public health authorities, and it prevents communal living arrangements, which obviously protects the population from spread of COVID-19. And long-term, we know that stable housing disrupts the cycle of poverty and leads to reduced rates of chronic disease, injury, stress, and diseases of despair. So with that, I would like to turn it over to my colleague in the Western region, Mila Balaza, who will continue with our groundbreaking cases of 2020 with our case in New York.
Thank you, Carrie. I am going to start with the Department of Homeland Security versus New York. And the Department of Homeland Security's final public charge rule was published in 2019. And it expanded the list of federal programs that could be used in a public charge determination. A public charge is an individual who is likely to receive certain designated public benefits, which can include SNAP and most forms of Medicaid, for a total of 12 months during a 36-month period. The public charge rule allowed the federal government to deny permanent residency to individuals that were found likely to become a public charge. So New York, Connecticut, and Vermont requested a nationwide preliminary injunction to block enforcement of the final rule. The U.S. Supreme Court stayed that national injunction, which was issued by New York Federal District Court, which meant that the federal public charge rule could be enforced pending appeal. At the time of this decision in January 27, 2020, there was actually allowance of, in Illinois, for it to still be blocked in Illinois because of a decision in that state. However, in February 2020, the Supreme Court lifted that statewide injunction, which meant that the rule could be enforced in Illinois as well. There's been some back and forth on this case since January. During the summer of 2020, the public charge rule was briefly halted due to a federal district court decision that ruled in favor of a nationwide injunction, and that was due to the COVID-19 pandemic. The Second Circuit later limited that injunction to just those original 3 states, New York, Connecticut, and Vermont. And most recently, in December 2020, the Ninth Circuit Court of Appeals enjoined the Department of Homeland Services from enforcing the public charge rule in 18 states plus DC, and that's because those were the states that were party to the lawsuit. Now, this is definitely has broad public health implications, and one of those is that the decision back in January, staying the injunction, which allowed the public charge rule to be enforced, meant that there was a reduced utilization of federal programs while the legal challenges moved through the judicial system. And there could be reduced utilization even for individuals who are not subject to the rule, such as individuals applying for certain visas. Add to that confusion of whether it was being enforced or not in certain states, as I mentioned, a decision in December 2020, certain states now, based on that Ninth Circuit Court of Appeals, were enjoined from enforcing it. So that leads to a lot of confusion and further reduced utilization of federal programs. I know that was a lot of information on this topic in a short amount of time, but I'm going to go to my next slide now, please, to keep in my time. But I could honestly do a whole webinar on the public charge, so I apologize for going so quickly in that case. I know all of these cases are so important. This case, In re SP, is a California Court of Appeals case, and it was decided in August 6, 2020. And what happened in this case is parents objected to their children's vaccination and argued that a juvenile court rejected a prior vaccination exemption that they had for their children. The children were dependent. They were under the custody and control of the county's Department of Social Services. The major holding of this case was the California Appellate Court ruled that the juvenile court could order the children to be vaccinated, and that was determined because the children's current pediatricians were recommending vaccination. And the appellate court also found that the juvenile court was reasonable in finding that the prior exemption was improper because it didn't meet certain requirements. It wasn't issued by a pediatrician, wasn't issued by the children's current treating physician, and it didn't list the medical reason for the exemption. So the public health impact of this is that a juvenile court having the authority to require vaccinations for dependent children, for these children, really could result in more children and increases the number of children that could be receiving vaccinations for the prevention of communicable diseases. It also indicates what exemptions would be considered valid and scrutinized to make sure they follow statutory requirements. And that's it. Thank you very much. I'm going to pass it now to my colleague in the Eastern region, Matt Swinburne, who's going to take a very important case out of Georgia.
My first case is a civil rights case. Bostock v. Clayton County was decided by the Supreme Court back in June of 2020. And this is actually a consolidation of 3 separate cases that all dealt with employees that had been fired based on their sexual orientation or transgender status. These employees asserted that their firings were discrimination based on sex and violated Title VII of the Civil Rights Act. Now, this sectional law prohibits employers from firing, refusing to hire, or discriminating against individuals based on their race, color, religion, nation of origin, or sex. Now, in this case, the employers admitted that they had fired the individuals because of their sexual orientation or transgender status, but they asserted that these actions didn't constitute discrimination based on sex. Now, the Supreme Court disagreed with the employers and held that discrimination based on either of these factors, sexual orientation or transgender status, was a form of prohibited sexual discrimination under Title VII. Now, the court reasoned that this was prohibited because sexual orientation and transgender status are inextricably linked to an individual's sex. The court also reasoned that if changing the employee's sex would have yielded a different choice by the employer, then it was impermissible discrimination under Title VII of the Civil Rights Act. Now, the potential public health benefits or impacts of this case are increased job security and the associated access to health care for homosexual and transgendered individuals. And it also has the potential to decrease the negative health effects associated with discrimination, which include increased incidence of anxiety, depression, and suicidal ideation. Next slide, please. All right, for my second case, I have one that deals with the SNAP program, the Supplemental Nutrition Assistance Program, still known by many as the Food Stamp Program. And this case was decided by the United States District Court for the District of Columbia. Now, this case deals with ABODs, able-bodied adults without dependents. And this is a classification of individuals who qualify for SNAP, but are subject to a special work requirement in order to receive the nutrition benefits. Now, the system allows states to waive these work requirements and grant exemptions when there are insufficient job opportunities in the community for these ABODs. Now, where the conflict occurs is that the Trump administration passed regulations that would have made it much harder for states to grant these waivers and exemptions, and an estimated 700,000 people were expected to lose their SNAP benefits. Now, these regulations were challenged by a group of states, cities, and private organizations who asserted that the regulations were an invalid use of agency authority. Now, the court agreed and vacated the regulations in a scathing opinion. First, the court ruled that the regulations were invalid on procedural grounds. The USDA had failed to provide the public with notice of the regulatory changes and an opportunity to comment on these changes as required by law, specifically the Administrative Procedures Act. Now, the second item that the court emphasized was that these regulations were arbitrary and capricious, which means that they were substantively invalid. The court said that the major substantive flaw here was that the regulatory choices made by the agency lacked any basis in evidence. There was no evidence to support the approach they had taken. Now, the USDA has already filed an appeal, but this appeal is likely to be dropped once the Biden administration assumes power. Now, in terms of public health benefits, it's pretty straightforward here. Now, this case protects the food security of the 700,000 people who are expected to lose SNAP as a result of these regulations. That's it for my slides, and now I'm going to pass it to my colleague, Sarah, so that she can discuss her two important cases.
Matt, first I'm going to talk about a Supreme Court case, County of Maui versus the Hawaii Wildlife Fund. This case is about the importance of protecting clean water for Americans, as well as protecting ecosystems through the Clean Water Act, which is known as one of the nation's more effective environmental laws. So at its most basic level, this case is about whether a wastewater treatment facility in Maui was violating the Clean Water Act by polluting the ocean indirectly through groundwater without a Clean Water Act permit, after the wastewater was discharged into wells. Pollution was causing some of the coral reefs in Hawaii to partially die, so this pollution was pretty transparent. But what started as this local water pollution case could have huge repercussions for clean water across the U.S. At issue in this decades-long dispute is whether the Clean Water Act requires permits for wastewater discharges that reach navigable waters like lakes, rivers, and oceans indirectly, such as through groundwater seepage. The Trump administration and others had taken an alternate, more narrow interpretation that the Clean Water Act only required permits for discharges that entered these waters directly from a polluting source. So on April 23rd, the U.S. Supreme Court issued their decision, and they held that the Clean Water Act does require a permit if the addition of pollutants through groundwater is the functional equivalent of a direct discharge from a point source into navigable waters. So in other words, the Clean Water Act prohibits the unpermitted discharge of pollution into navigable waters, or when the discharges reaches the same result through roughly similar means. So this opinion, it was with a 6-3 vote, and it's really important because it prevents the very type of discharges and pollution that the Clean Water Act is designed to protect against. It focuses on the environmental impact rather than on the means of causing that impact. And it closes the loophole so that the same polluters can't go unregulated or unpermitted simply just by changing where or how they discharge their sewage. Next slide, please. So next we're going to talk about Roman v. Wolf, a U.S. Court of Appeals case coming out of the Ninth Circuit. This is coming out of Southern California. Throughout the pandemic, public health authorities have emphasized that maintaining a social distance of 6 feet is really crucial to preventing the spread of COVID-19. But conditions at the Adelanto facility, which is used by U.S. Immigration and Customs Enforcement, ICE, to detain about 1,300 people, it really made maintaining that 6 feet social distance impossible. So the ACLU of Southern California filed this class action lawsuit on behalf of detainees, asking the facility to reduce the number of persons and to provide other hygienic necessities. There were overly crowded cells, overly crowded dining spaces and bathrooms, so it was just impossible to maintain social distancing and to sufficiently disinfect or clean the spaces. The ACLU argued that the conditions violate detainees' Fifth Amendment rights. Whenever the government detains or incarcerates someone, it has an affirmative duty to provide conditions of reasonable health and safety. The Supreme Court has previously explained that when the state takes a person into its custody and holds him there against his will, the Constitution imposes a corresponding duty to assume some responsibility for his safety and general well-being. And that holding was from Descheny v. Winnebago back in 1989. So here, first in the district court, they did grant a preliminary injunction and ordered Adelanto not to accept more detainees and also to reduce the current population to allow for sufficient social distancing. Then here, the Ninth Circuit Court of Appeals agreed that the government failed to provide reasonably safe conditions, but then they sent the case back to the district court to assess the conditions just since 5 months had passed since the district court heard the case in February to assess what the conditions required. So why is this important? As of September 2020, when this case was decided, there were 114 COVID cases among the Adelanto detainees and staff, meaning that about 10% of persons at the facility were testing positive. So that's after that preliminary injunction had already been in play, which calls into question how much worse it would have been if the injunction had not been issued, and also what is still needed. Clearly, there's still these conditions that allow this contagious virus to spread rampantly. So while this decision does help ensure that these facilities are kept accountable for protecting the health of both the persons detained as well as staff and protecting against inhumane conditions, still it kind of leaves some questions of what really is owed with that duty to assume responsibility for the health and safety of persons there. So next slide, please. And now I'll turn it over to my colleague, Brooke.
Right, thank you. This case, Agency for International Development et al. Versus Alliance for Open Society International et al. This was a Supreme Court decision. The majority opinion was delivered by Justice Kavanaugh, though there was a lengthy dissent by Justice Breyer. And this case stems from a 2003 act passed by Congress known as the Leadership Act, which requires those who receive federal funding to explicitly adopt policies opposing prostitution and sex trafficking. The plaintiffs here, they are a group of American NGOs with foreign affiliates who also receive money from the Leadership Act to combat HIV and AIDS, the AIDS epidemic here and abroad. And in 2013, actually, these same plaintiffs brought a similar suit, and the Supreme Court found that this requirement violated the First Amendment rights when applied to U.S. NGOs. And here they are back again filing because they have concerns about their First Amendment rights still. When the court decided this case, they framed this issue very narrowly. They looked at this as whether foreign NGOs possess First Amendment rights and then whether the funding requirement violates them. And so the court ultimately held that foreign NGOs do not have First Amendment rights. So the funding requirement cannot violate them. And I just want to mention there's a powerful dissent, like I said, by Justice Breyer. And what Justice Breyer says is the majority here is asking the wrong question. The real question is whether the First Amendment protects Americans when they're speaking through these clearly identified foreign NGOs, foreign affiliates. That's why the plaintiffs here filed the case. They didn't assert that these foreign NGOs have First Amendment rights. They're asserting that theirs are impacted because of this policy and the impact it has on their affiliates. And so these U.S.-based NGOs and their foreign affiliates, they're conveying this clear, consistent message. They have the same logo, name, and branding, and what matters is that the affiliates are clearly identified as being affiliated with the U.S.-based NGOs, not that there happen to be these separately incorporated foreign entities. So technically they're different guests, but constitutionally they are the same speaker. And so the public health impact of this is that yes, the U.S. may continue to exert influence over these policies adopted by foreign NGOs, but more specifically, a U.S.-based NGO with these clearly identified affiliates are going to have to adopt very different messaging when a condition of funding requires it. So one, that might cause confusion if the entities appear to be, and for all intents and purposes, are one entity. And two, it could make it more difficult to carry out the goal of combating HIV and AIDS overseas. The reason being that the concern is by adopting this policy statement, it sometimes can alienate certain host governments, making it more difficult to work with them. Next slide, please. All right, Mayor and City Council of Baltimore v. Azar. This was a Fourth Circuit Court of Appeals decision. It was issued by a split court. This concerned an HHS rule that banned federally funded healthcare providers from referring patients for abortion, instead requiring prenatal care referrals. Also, it required entities providing separately funded abortion services to physically and financially separate from the federally funded ones. The court ultimately affirmed the lower court's ruling and held that HHS could not enforce that rule, but could not enforce it in Maryland specifically. And the court had a detailed reasoning for this. So first, they say the final rule was promulgated in an arbitrary and capricious manner. Every major medical organization had grave concerns, and HHS just responded that it didn't believe that these concerns were an issue, essentially. They also said HHS estimated the cost of financially and physically separating would be $30,000, but the administrative record estimated far higher, and HHS didn't have a substantive response. Second, the court said this final rule was not in accordance with law. To receive the federal funding, all pregnancy counseling was supposed to be non-directive, meaning that the pregnancy counseling should meaningfully present all options, and not referring or discussing abortion would violate this. There's also the non-interference mandate. The ACA says that HHS shall not promulgate any regulation that interferes with communications regarding a full range of treatment options between the patient and provider. Clearly, communications are being interfered with when the provider cannot mention abortion. And so, like I said, the ruling is specific here in Maryland. And so, yes, federally funded healthcare providers can continue to refer patients for abortion, and it won't require that physical separation for services in Maryland. But as far as nationwide, as of February 2020, 1 in 4 federally funded sites had withdrawn from receiving funding, and this jeopardizes care for 1.6 million patients nationwide. also specific to Maryland. Since these facilities are shutting down at alarming rates in other places, it could have the impact of overwhelming the programming here in Maryland, since there might be fewer services to go around and people might come to Maryland for those services. And with that, I'll turn that over to Jen.
And what a great segue. The first case that I'm going to be talking about is June Medical Services versus Russo. This was a case issued by the United States Supreme Court on June 29, 2020. In this case, several abortion clinics and doctors challenged a Louisiana law that required doctors to have admitting privileges at a hospital within 30 miles of a clinic where an abortion is performed. Now, this is a repeat performance for the court, as the language in this law was virtually identical to language in a Texas law that the court struck down in 2016 in a case called Whole Woman's Health versus Hellerstedt. The most substantial change between the two cases is actually the makeup of the court itself, via the departure of Justice Kennedy and the addition of Justice Brett Kavanaugh. Now, the court here issued a somewhat interesting decision. Chief Justice John Roberts issued an opinion concurring in the judgment with the opinion written by the liberal wing of the court, Justices Breyer, Ginsburg, Sotomayor, and Kagan on board. Now, the general analysis in these types of cases, per a prior case called Planned Parenthood versus Casey, is looking at whether a law poses a substantial obstacle to women seeking an abortion. Now, Whole Woman's Health clarified this analysis by adding a balancing test, balancing the health benefits of the law against the burdens it imposes to determine whether a substantial obstacle exists. So the liberal justices in June Medical Services noted that they would conform to this Whole Woman's Health balancing test and held the Louisiana law unconstitutional. Chief Justice Roberts joined this wing in striking down the law because of its similarities to Whole Woman's Health. Nevertheless, Chief Justice Roberts indicated that he believed Whole Woman's Health was wrongly decided and that he would not use a balancing test, instead preferring to determine whether a restriction presents a substantial obstacle under Casey. So what are the public health consequences here? The right to abortion is at stake, and the potential for the court to swing wide into allowing more stringent limitations of that right is indeed possible. This case indicated that the court would continue to follow prior abortion jurisprudence, with the potential exception of that balancing test enunciated in Whole Woman's Health. This past year, however, with the passing of Justice Ruth Bader Ginsburg, it's highly likely that that Whole Woman's Health balancing test will be fully eschewed in favor of returning to Casey and the plain substantial obstacle test, and yet to be determined is the full impact of Justice Amy Coney Barrett's confirmation to the court. Next slide, please. Now, our next case is Parents for Privacy versus Barr, and this is a Ninth Circuit Court of Appeals case that was issued on February 12, 2020. In this case, parents on behalf of their students alleged that an Oregon school district's policy permitting students to use facilities matching their gender identity violated the Constitution's 14th Amendment rights to privacy and parental rights, the First Amendment's protection of free exercise of religion, and Title IX federal civil rights protections. The Ninth Circuit addressed all of these arguments on appeal and affirmed the trial court's full dismissal of the case, determining that the plaintiff's claims were non-cognizable. Specifically, the Ninth Circuit determined that there is no 14th Amendment fundamental privacy right to avoid all risk of intimate exposure to or by a transgender person. The 14th Amendment also does not provide a fundamental parental right to determine the bathroom policies of the public schools to which parents may send their children. With respect to Title IX, the court concluded that a policy that treats all students equally does not discriminate based on sex in violation of Title IX, and the normal use of facilities does not constitute actionable sexual harassment under Title IX just because a person is transgender. Finally, with respect to the First Amendment free exercise argument, the court held that the plan was neutral and generally applicable and did not infringe plaintiff's freedom of religion. And on December 7th, 2020, the U.S. Supreme Court actually denied review in this case. So the public health consequences here are clear. The policy stands as one way to avoid any detrimental mental and physical health effects that result from excluding transgender students from facilities that match their gender identities. As illustrated by the American Medical Association amicus brief, living one's life in accordance with gender identity is critical to mental health, as exclusionary policies can exacerbate anxiety and depression, low self-esteem, and engaging in self-harm, among other negative consequences. So the Ninth Circuit and the District Court in this case acknowledged that the school's plan here was a plan meant to protect student safety and well-being and to eliminate that discrimination on the basis of transgender status. And with that, I will hand it over to Kathy to take us through some incredibly impactful cases out of the Eastern region. Kathy?
Thanks, Jen. My first case, Roman Catholic Diocese of Brooklyn versus Cuomo, is one of our COVID cases, right? COVID has brought us quite a bit of case law, and this one perhaps not optimal for public health. Comes out of the Supreme Court as we are about to start our holiday break for Thanksgiving. New York State had designated areas in the state as yellow, orange, and red based on their COVID risk. In yellow areas, houses of worship were limited to 10 attendees, in orange, 25, and in in 10 in red, 25 in orange, and 50% capacity in yellow. There were varying provisions related to other businesses, essential businesses, which did include acupuncture facilities, campgrounds, and auto mechanics, had more generous provisions, and other locations had similar restrictions to the houses of worship. Most significant here, however, is that the regulation specifically designated the attendance limits for houses of worship and didn't simply include them in a definition of other comparable indoor gatherings. The Supreme Court took hold of that and said that because the state had singled out houses of worship for, quote, especially harsh treatment, the strict scrutiny would apply here, meaning the state needed a compelling state interest and had to narrowly tailor the response to that interest. The court did find COVID control to be a compelling interest. The state needs to control the outbreak of the pandemic, but that the restrictions were not narrowly tailored. The court based this decision on the fact that there were no outbreaks associated with houses of worship and that other states had lesser restrictions for houses of worship. As a result, the court found that the restrictions specifically applying to houses of worship did violate the First Amendment. It's a bit concerning because obviously it interferes with the public health powers of state and local jurisdictions to regulate in the face of the pandemic. I will point out that Justice Barr, in his dissent, really relied on epidemiology to say there is a difference between houses of worship and what happens there and the potential spread and these other businesses where folks come and go for short periods of time. And Justice Sotomayor indicated that it should not be the province of courts to jump in with these judgment calls in making these decisions. But I think for us, we take away from this a concern about singling out houses of worship in any of our regulations. And so moving forward, it's best to have broad application to places of indoor gathering and not make those distinctions between secular and non-secular. Just as Leva indicated, I could talk about this case all day, but next slide, James, we will move on to my second case, which is the National Prescription Opiate Litigation. This case was first created as a multi-district litigation, meaning lots of cases wrapped into one in December of 2017. I just want to situate that more than 3 years ago. The hope with this effort here by the lower court was to expedite a settlement in this case. So this case involves over 2,000 cases, 33,000 cities and towns that have sued the opioid manufacturers and distributors in light of the opioid epidemic, the epidemic we had prior and still have during COVID. The lower court approved of the creation of a class of representatives of the plaintiffs. So meaning of all the cities and towns, they would agree to have this class, a certain group of them, that would negotiate on behalf of all cities and towns. The negotiation would actually then bind the cities and towns, even those who had not brought suit yet, to the decision made with respect to a settlement with the drug manufacturers. The trial court did approve that, but the Sixth Circuit, as you can see here, did not, and found that the federal rules of civil procedure do not allow for this type of class formation that would bind municipalities before settlement terms were even available or before even some of them had filed suit. The big takeaway here from a public health perspective, and why I pointed out that it's been 3 years since this case started, is that we're not going to see an expedited resolution of these cases and money flowing into the communities that really need it to remediate the damages of substance use disorder in their communities. And so hopefully the cases will proceed with some of the bellwether cases are proceeding with damages, but otherwise we're not going to get a quick action out of the multi-district litigation. I hand it back to James.
Okay, Kathy, thank you so much. What an incredible outlay of information in regards to what we were seeing in 2020 in regards to judicial trends. In just a moment, we're going to turn to your questions and comments for the purposes of assessing all the different issues you've seen in these cases. We'll bring some of those case decisions back up when we're taking your specific question. Let me encourage you now, use that Q&A function in the Cisco web systems. Go ahead and put your questions in there now. We'll look forward to them in just a second. First, however, I'm delighted to introduce what we call a lightning round. Now listen, here's what we're trying to accomplish here. You've heard about where we've been in judicial cases in the last year, and what a remarkable year 2020 was. Where's it going? What are our projections ahead? What are we looking at closely in regards to the next year? So without further ado, this is a lightning round. I'm inviting all of my panelists to go ahead and unmute because it's coming your way very soon. I'm bursting it to the person with our hot hand, and that's Kathy, coming off those two great cases. Kathy, what's your 1-minute projections? 2020 judicial trends.
My projection is that because we now have a bench that is heavily tilted toward Trump nominees, and we're going to start seeing a lot more conflicts between the federal district court and federal appellate court decisions across the country. What does that mean? At the end of the day, I don't know where the balance falls from a public health perspective, but I think we're unfortunately going to see different areas of the country mustering under different legal outcomes. Does that mean the Supreme Court is going to take more cases because the Supreme Court tends to take cases that are splits among the circuit? That I don't know. They can only handle so much work, unless, of course, the court were to be expanded. Mic drop.
We'll see. Great point, Kathy. All right, let's head back out west. Leela, our colleague out west in the Western region. What's your takeaway, your 1-minute assessment of where we're going with judicial projections? Leela.
Thanks, James. My judicial projections include an increase in legal challenges to vaccine laws, specifically possibly in later this year when we aren't seeing such scarce allocation of vaccines, but maybe as vaccines are more widely available, with discussions of whether schools or employers will require the new COVID-19 vaccine. So my prediction is seeing some legal challenges and to existing vaccine laws.
Leave a great point. I see it as well. Back east, let's head to our colleague, Carrie Lowry. Carrie, what's your projections?
Thanks, James. This is just really hard, but I think that we're going to see a lot of challenges because of what Kathy talked about, the current makeup of the Supreme Court and the current climate and the new administration. I think there are going to be a lot of innovative or progressive measures that are aimed at controlling COVID-19. And I think that we're going to continue to see decisions that emerge out of that kind of challenging those measures. And, I'm kind of hinting very not so subtly at Brown versus Azar and what happens there in terms of what the executive's power is to take those kinds of broad measures.
Great point, Carrie. No doubt. Brown versus Azar, we got a lot to learn from that decision. More questions forthcoming. Jen, thoughts, comments about where we stand with key judicial projections going forward?
I think it's incredibly likely this year that we're going to start seeing huge increases of cases seeking out changes to abortion access. If we do not see a wholesale overturning of Roe versus Wade, which I don't think is necessarily likely, then we're going to see several cases trying to start opening that door a bit wider for state abortion restrictions. Also, I mentioned this a bit previously, but I think it's highly likely that in the next abortion case that the court hears, the court is going to fully get rid of that balancing test set forth in Hellerstedt and instead refer back to the Casey substantial obstacle test. And the result there might be a standard allowing for laws that really have little or no benefit to women. So this is going to be really important to watch for.
No doubt about that, Jen. And to that end, let's turn back to our Eastern Region colleague, Matt Swinburne. Matt, what are you projecting?
My hot take is not that hot. What I do a lot of work with is food security. And so my projection is going to be related to the USDA. I think with the coming of the Biden administration, that administration is going to undo a lot of the harmful policies that were put in place during the Trump administration under the guidance of, Sonny Perdue. So I think we're actually going to see less legal challenges in the courts pertaining to nutrition programs run by the USDA. For example, there is a proposed regulation that was put out there by the USDA regarding categorical eligibility for the SNAP program that is projected to have a horrible impact in terms of 3 million people losing access to SNAP benefits and an ancillary effect of 500,000 children losing access to school nutrition programs. But I have a feeling that's going to be a proposed regulation that is repealed with the transition of power, and I think you're going to see that trend of trying to undo some of those dangerous policies, and as a result, less judicial action on this.
Matt, great points. Let's turn back now to our Western Region colleague, Sarah Weather, for your key assessment.
Yes, it is likely that this year I predict we'll see a lot more action in the courts surrounding environmental protections. It's predictable that the Biden administration, with the plans to rejoin the Paris Agreement and combat climate change, they will issue stricter regulations around things like pollution and greenhouse gas emissions. And these new regulations will likely be challenged judicially. So how will the courts respond? Now, with the 6-3 conservative majority, it's predictable that these stricter environmental regulations could get weakened or thrown out at the Supreme Court level. But still, the County of Maui case that I talked about before, that was decided by a 6-3 majority with some of the more conservative justices like Justice Kavanaugh joining that majority. So still there's a lot of questions up in the air. There's hope that with all these national efforts and movements to tackle climate change gaining popularity both within the general population and hopefully among the courts, that hopefully we'll still see some stronger environmental protections survive any legal challenges.
Sarah, nicely stated. Thank you so much. And then back east to Brooke Torton. Brooke.
Thank you. So as to the mayor and city council of Baltimore versus Azar case, and this was the HHS rule that I mentioned referring to federally funded family planning services. So given that we have this new federal administration that's incoming, I think that the rule will likely be revoked. Like I said, the decision only applied to cases in Maryland, and so I think the Biden administration will likely try to get rid of this rule, but that might take a little bit of time. Obviously, HHS is going to have their hands full, particularly after this year, and so it's possible we might see other challenges in other circuits since this only applies to the state of Maryland. And the other thing I want to mention, we've heard a lot about the makeup of the Supreme Court from my colleagues. In my Agency for International Development case, I mentioned that in 2013 there was a very similar case filed by the same plaintiffs. And I just want to mention that the case that was decided in 2020, it could have come out differently. They could have used some of the precedent discussed and established in that case. It seems to me that the only real thing that changed was the makeup of the court. And so I think we might see more of that not just with respect to public health issues, but generally speaking, I think the makeup of the court is going to overturn precedent in many ways in coming years.
Brooke, thank you. Well stated. Listen, I'll play wrap up on this, and then we're getting right to your questions and comments in just a moment, some of which have been pre-submitted in advance to us. We'll take some of those too and take your live questions as well as showing up in the Q&A box is where we're monitoring very closely. Start putting your questions in there in just a second. You know, my judicial projection for 2021 is something, I'm not saying I saw it from a year ago, but I will say expect it sometime this year with the new members of the U.S. Supreme Court, which have changed the game drastically. And you've heard all of us talk a little bit about what might be forthcoming from that level of jurisprudence. We are going to see, I think, in 2021, some Jacobson-type decision forthcoming, a decision that changes the game for what we do in public health law and policy for the next century ahead. I'm not projecting what the facts will be. I'm not projecting what the court's demeanor will be, but I will say that decision is projected or predictable, I think, in 2021, especially as we shift now into a new administration that's got a very new priority set for how we'll respond in real time to COVID-19. Lots more to be done on that front. We'll project maybe a little bit further with some of our Q&A. And to that end, let me turn directly to our questions and comments. And I'm going to start with, and believe me, all of our presenters, it's coming back to you at some point or another as we're monitoring questions very closely right now. But Jen, let me turn to you, if I may, with a question that plays a little bit off of your projection and actually plays off that pivotal case, June Medical Service versus Russo. So listen, in the last, couple of weeks or so, we saw the U.S. Supreme Court issue its FDA versus ACOG decision. And without question, that may implicate the future of abortion rights jurisprudence, but what's your take on what the court's saying there and its potential for implications down the road?
James, and first, just to make sure that we're all starting from a base level here, I'll talk a bit about this decision. The decision involves an FDA rule requiring that an abortifacient drug, mifepristone, has to be obtained in person at a clinic or hospital. And this means that it can't be mailed or picked up at a neighborhood pharmacy. So women are allowed to self-administer mifepristone once they get home, but they have to leave home in order to obtain it. And the FDA versus ACOG decision that James just mentioned, that just came down on January 12th. The background there was that a federal district court actually blocked the rule's enforcement during COVID-19, concluding that the rule presented a substantial obstacle to women seeking an abortion during the pandemic. Well, the U.S. Supreme Court, within the past few weeks, intervened and actually blocked the district court's ruling, waiting for an appeal to come out of the Fourth Circuit. So that means that the rule can be enforced. The court's decision here was incredibly bare on explanation and analysis, not leaving a ton to draw from in terms of actual language of interpretation. That said, the reason this decision may signal a change in abortion rights jurisprudence ahead is that prior to Justice Amy Coney Barrett's confirmation to the court had actually declined to intervene in the case, simply asking the lower court to reconsider and see if circumstances had changed to justify lifting the ban. So the court's desire to interfere at this point, after the confirmation of Justice Amy Coney Barrett, could indicate that potential shift in abortion rights jurisprudence may be incoming.
Jen, nice analysis. Thank you so much. So, again, reminder to all attendees, if you have specific questions related to the cases you've heard about, we'll post those again, and relevant cases will be put back on screen in just a moment. But to be sure, let us know through the Q&A portion. Sarah, this question's coming to you. It comes in relation to your case, Roman v. Wolf, which is up on screen here in just a second. And to be sure, the nature of the question is really quite straightforward. Could the Eighth Amendment be used to close the DHS facility given transmission rates during the pandemic? Thoughts, comments?
That's a really interesting question. Thank you so much. So the Eighth Amendment prohibits, in part, cruel and unusual punishment for related to criminal convictions. So it's interesting to think about how being confined in one of these centers actually constitutes cruel and unusual punishment in the sense that you're subjected to possibly getting this highly infectious disease. At first thing I want to point out is detention centers like these for immigration, they're not being criminally detained in the sense that no one has been criminally charged. Rather, they're being held while their immigration status are in question. So they're not being criminally detained in this particular facility, but we can certainly think more about how this might apply to something like federal prisons where criminals are being held. So it's something to definitely think about. I think Fifth Amendment as relates to health and a health condition that is not, it's not the actual punishment. It's more as an effect of these poor conditions at this facility. So while the Fifth Amendment might be a little bit clearer and easy to argue, there might be more precedent in place to kind of rely on, but certainly interesting to think about how conditions brought by COVID-19 and maybe even future infectious outbreaks could invoke the Eighth Amendment as in regards to criminal detentions.
Very nicely stated, Sarah. Thank you. Brooke, next question up for you. It relates to your Mayor and City Council of Baltimore versus Azar case. And to be sure, what you suggested in very nice synopsis there is HHS's rule prohibiting federally funded healthcare providers from referring patients for abortion. But, the question may underlie how did HHS justify the rule to begin with? What arguments favored it?
Sure. So there were really several arguments here, and I'll pick a few of the main ones. Well, what the Fourth Circuit kind of rested its hat on was this medical ethics case that HHS didn't really address the arguments of every major medical organization. And so what HHS says in response is that they say that this case, there was a Supreme Court case, Russ versus Sullivan, and that case dealt with these regulations passed in 1988 that look almost identical to these, and that the court dealt with that issue and all of the other issues there, and so there's precedent that should not be overturned. But the court here responds and say, yes, Russ dealt with these very similar, if not identical, regulations, but it did not address this very medical ethics issue. In fact, at that time, the medical community didn't come out and make the statements and the arguments that they did for this particular case. There was another argument that dealt with conscience statutes. And so these federal and state conscience laws that have, I think, existed since the 1970s, they've protected the ability of healthcare personnel to not assist or refer to abortions in the context of HHS-funded or administered programs. And so HHS said these are necessary to comply with those federal and state conscience laws. And the court says, no, these conscience statutes are not relevant to that particular question. Allowing a physician with a conscious objection is one thing. Prohibiting a physician from providing, full and accurate information is very much another. So those were two of their bigger arguments.
Brooke, thank you so much. Nicely stated. Kathy, this question's coming to us directly from the active Q&A for sure, and it's an interesting question. I think with your experience, you're well positioned to help us think through. It basically goes along the lines of whether or not what we really need to see in regards to an empowered or funded national public health infrastructure, is that enough, is that enough to bring about change, or do we need new sort of public awareness about and how we actually think through these things politically? So the type of state-to-state variation we've been seeing, as one of the commenters notes, has been so profound in response to COVID-19. What and how do we get past that in 2021 judicially? Any thoughts, comments, Kathy, this year?
Sure. Yeah. I mean, typically, before COVID, my mantra has always been keep it local, right, in public health. That is where we've seen innovation, where we've seen dynamic public health laws, where we can test and see if things are actually effective, and then we work them up the scale to state laws and sometimes into federal laws. And that's for the federal government to kind of stay out of the business of public health, except for, kind of broad programming like SNAP or, federal housing benefits and the like. However, when it comes to a pandemic, the lack of federal infrastructure, not to do the work necessarily that the locals and the states are doing, but to help manage, to help distribute, to help set up systems so that we could have better, better and quicker testing, so that we could have now better distribution of the vaccine, better tracing and reporting. The lack of any of that at the federal level clearly imperiled the country and, has led to our standing kind of globally with far more outbreak than we likely should have had. So my hope and what I think is consistent so far with what I've heard from the incoming administration is that there will be an emphasis on what I want to call it the kind of the skeleton, right? Building up the skeleton of the federal system in public health, so that when we have to rely on it, it's there. But the muscles and tendons and flesh that's always been what really makes us move in public health will remain with the state and local government. But I do think it is time to turn our attention to building the federal infrastructure for public health. That is going to take a lot of money. It's going to take a lot of effort and a lot of attention. If ever there was a time to capitalize on the fact that the public is paying attention to public health, now is that time. And so we may well see some progress in that respect.
It's a positive projection, Kathy. I like it as well, and I appreciate it in response to some of what we're seeing with good Q&A. Nice reminder to all attendees. We're in that active Q&A role. Go ahead and place your comments in the Q&A box. We're checking them closely. Next question up, however, is a clarification on Brown versus Azar. And Carrie, it's coming your way along the following front. So, this eviction moratorium result from CDC is so critical. It's made such a critical difference for so many Americans. Where are we going from here? What are the implications for future moratorium efforts? Can you give us some sense of where you think things will head?
Yeah, thank you, James. It's a big question, and I'll do my best. So with regard to Brown versus Azar itself, I mentioned it's been appealed to the 11th Circuit. We're still waiting on the decision there. The 11th Circuit also hasn't ruled on a motion for injunction pending appeal. And so, the refusal to enjoin the CDC order still stands as of right now. And arguably, because we are now in January and the order is set to expire at the end of January, the question is, once the 11th Circuit considers the case, is it going to be dismissed because it's moot at that point? So there is an exception that was carved out by the Supreme Court where they will agree to see cases that are technically moot but are what they call capable of repetition but evading review. And those are matters that are likely to happen again and again, but will always probably have these kinds of timing issues. And so it's possible that the 11th Circuit and then possibly the Supreme Court will consider whether the CDC in fact had the authority to grant a nationwide moratorium on evictions. And so I think that there's a good chance that we'll actually see some kind of Supreme Court weighing in on this issue in particular. We do know as far as where do we go from here on evictions, it's a huge issue. And like Kathy said, it's going to take a lot of money and it's going to take a national effort. Biden has revealed that he'll ask Congress for about $30 billion in rental assistance and an extension of the ban on evictions and foreclosures until the end of September 2021. If Congress doesn't comply with that, there's a good chance that the new administration, I would say, will almost certainly implement a similar executive ban on evictions to the CDC order. And again, that circles us back to Brown versus Azar and what happens in the courts with that, with regard to whether that will be upheld.
Carrie, thank you so much. Jim, let's go off script for a second because we got a great question, and I think you and I might be able to give a quick answer to it. It comes to us in the following form: given the spread of misinformation throughout the pandemic, including by licensed healthcare professionals, which is rather shocking, do you see any potential issues related to discipline of these professionals by licensing boards or implications for professional speech? So, Jen, let me address one facet of it, and then you address a second facet, which I know we're looking at in regards to some of our work out west. It relates to the economic due process issues of licensure and all the concerns there. But if I may, the first response I'll give is as follows. Listen, First Amendment protections for what you can say and do in relation to how far we go in actually providing protections against licensure, sanctions, or otherwise, stop at the door of fraudulent, false information. You just don't have First Amendment interest to actually spread knowingly false information. And that's one of those parameters through which, from a First Amendment perspective, we think through licensure board applications in regards to medical doctors or others who are actually knowingly spreading false data, false information, incorrect potential ramifications with repercussions on public health from a COVID perspective. But whenever you get involved with licensure issues, Jen, you know we're going to trip in some issues on due process and other concerns, including these sort of emerging economic due process issues. Any thoughts, comments to raise there?
Sure, James. Thank you. And I absolutely agree with you. That's false, fraudulent speech. That is not going to be protected by the First Amendment. And certainly any kinds of actions taken against these statements will depend on your state-specific licensing board and what kinds of regulations or limitations that state board puts out. Now, with respect to economic due process, there's always the argument in the background that maybe these professionals would make, which could be, I have a right to pursue my chosen vocation. I have a right to pursue my work, and you're violating that right by disciplining me here. That's not going to be a good argument. That's not going to be a good argument, because the fundamental reason that we have professional licensing boards is to protect the public's health. And these licensing boards are enabled to take certain actions against professionals who violate those rules, who go against what they should be doing, which is protecting the public's health. So when you're talking about economic due process arguments, I don't think that has as much space here in terms of false, fraudulent, misleading language, for sure.
Jen, thank you so much. So here's an important question coming in relation to the issues you raised, Matt, in District of Columbia versus USDA. And the questions actually extend from all the different legislation we've seen Congress be forthcoming in regards to COVID-19 relief bills. Matt, what we're seeing in relation to those is the potential for perhaps to address some of the ABA-WD work requirements that you were discussing in the case. What's your take? Is it true?
So the ABOD work requirement is momentarily waived because of the economic conditions in the United States. And that was done with the first set of COVID relief legislation, the Families First Coronavirus Response Act. Now, here's the challenge and why, it's especially important that the court struck down these regulations. The waiver of the work requirement that the the Family First Coronavirus Response Act put in place, the duration of that waiver is linked to the termination of the federal declaration of a public health emergency. Now, the economic pandemic that is, coinciding with COVID is expected to last much longer than the pandemic itself. So, economic projections are looking at the U.S. economy recovering to kind of pre-COVID levels sometime in 2023. So the waiver is protecting people right now, but when the public health emergency declaration is terminated, those individuals would have been subjected to the Trump administration's restrictive regulations that would have, kicked 700,000 people off of the SNAP program. So, the decision was really important because those individuals would have been kind of left searching for a job in an economy that was still debilitated from the COVID pandemic. So there is kind of an interplay between the COVID relief and this ABOD case, both trying to protect these folks during these troubling times.
Matt, thank you so much. Leila, question in relation to the important Supreme Court case DHS versus New York, and the question extends actually from whether children's benefits might be included in a parent's public charge determination. Any thought of whether the court addressed this or your thoughts related to it?
Thanks, James. The children's benefits are not taken into consideration for a parent's determination of public charge. And I think that it's a great question because it does highlight the confusion around the decisions and the implications of the public charge rule, and whether, the confusion of whether it's being enforced or not, but also who it applies to. And so I think that is an important question for people to know, and adds to that, obviously highlights that confusion that can result.
Leila, thank you so much. Brooke and Sarah, because of your cases you've chosen, but also I know your expertise and backgrounds, international questions has come forward, and it goes to something along the following lines. Let's hear first from Brooke, and then Sarah, thoughts about whether and how to use the Declaration of Human Rights or other international legal mechanisms to potentially respond to COVID-19 in recognition of how it's massively impacted the United States. Thoughts? First of all, Brooke.
So I suppose it would have to, COVID is such a broad topic. Do we mean specifically how this would impact, how to use it to address the spread of the virus, or what specifically?
Yeah, it's a great point. I think probably what we're hearing is a recognition that the Biden administration may have a considerably different approach to recognition of human rights globally, and what repercussions that may have for us in the United States in response to COVID-19 efforts. Any thoughts to share?
Yeah, so I guess, part of what I'm thinking is vaccine distribution. I think that this is something that we can, examine with respect to human rights. How I think that's going to be probably a big topic, and how that might be used to equitably distribute so that we can get this pandemic under control. So I kind of see there being an overlay there with respect to distribution. That's kind of the first item that popped into my head. But I'm not sure I have any other, other comments on that. I guess it's such a broad topic. I think certainly if there's a way to apply it to any aspect of this pandemic, we should.
Great point, Brooks. Sarah, what's your perspective?
Sure. In thinking about human rights and the Declaration of Human Rights, UN Secretary General Antonio Guterres has stated the importance of really placing human rights at the center of the COVID response. But still, there's a lot of questions about really kind of what Brooke was saying. What are actually states' responsibilities in preserving human rights through controlling COVID, especially in something that's so epidemiologically complex. So it's hard to really state what nations' responsibilities are when it comes to that. But I think it's something that in the aftermath of COVID will certainly be explored, as well as thinking to international law more broadly. We have the international health regulations, which place obligations on nation states more in the realm of detecting an infectious outbreak that has the potential to cause a pandemic and alerting the World Health Organization, alerting other countries. But then once that happens, there's not a whole lot of obligations that states have in terms of actually controlling the virus. So I think there'll be also a lot of attention in the aftermath of COVID on the international health regulations and what types of options or obligations states should have in controlling a virus that transcends borders. And then again, what type of responsibility or roles the WHO can have in actually enforcing those types of measures.
Sarah, thank you so much. Brooke as well. Kathy, question in regards to the pivotal decision you mentioned so nicely earlier at the top of at the end of our program related to the Cuomo case out of New York. And I think a question a lot of people are starting to assess and wonder about what the court's basic sort of opinion and or next steps may be in regards to what sort of impact it means for state and local governments. Can they not actually restrict or regulate houses of worship in regards to attendance following a case like this without tripping on First Amendment concerns? What's your thought, Kathy?
So the case that I spoke about, it related to a temporary restraining order. New York had already kind of descheduled down the restrictions on houses of worship, so it was kind of moot. So that opinion itself is only kind of worth the kind of peek that it gives us. But I guess that's what the question is asking. What does that peek tell us? I think the bottom line, and what's always been best practice, is to not have restrictions that specifically delineate the requirements or prohibitions for religious organizations or religious entities. So you can have restrictions about attendance at indoor gatherings of a certain, size limits or, capacity limits. Just don't add into the regulation that it's specifically applying to houses of worship. What clearly bothered the court in this case was that there were specific provisions for houses of worship. The majority argued that some businesses were treated more favorably than the houses of worship, but those businesses were like a bike shop where somebody might come and go and is standing there singing and shaking hands for an hour and a half or so. And the dissent argued that, there were secular businesses that were treated more harshly than houses of worship. Anytime you're engaged in that particular battle with this particular court at the helm, you're not going to be in a great place. So the best place to put yourself in is where you have broadly written restrictions that apply to all indoor gatherings or outdoor gatherings, if that's what it is, but don't specifically designate provisions that relate to houses of worship, because you're going to fall into that, is it stronger or weaker than what you're applying to secular organizations?
Great information, Kathy. Thank you so much for your interpretation on this total case, and more to come along the same lines of it, I dare say, in 2021 from this court. Okay, time's drawing close to the end. Soon we'll be wrapping up the program. One final question. I'm going to send it our way to our Western Region colleague, Leela Barraza, in regards to your assessment of the case Henri SP. So, Leela, just a quick question for us before we wrap up our program and all the different assessments we've made across all these great cases. So, listen, in this case, you actually, assessed what the parents' opportunities were. Could they have actually sought a philosophical exemption for their kids in this specific vaccination case?
Thanks, James. No, actually, so the case came out of California, and in California, there are only medical exemptions allowed for vaccination. They do not allow non-medical exemptions under their law. And the case was really stemming from a recent enactment of a California Health and Safety Code that provided that a state public health officer or physician could revoke a previous medical exemption, and that's because their law only permits medical exemptions.
Leela, thank you so much. So now as we draw to the end of our program, let me take us to our last slide. Any final comments from our colleagues or presenters today? I'll take that as a very good sign, and without further ado, turn it back over to our colleague Charles to wrap us up. Thank you so much for everyone attending to get the insights of what we've seen over this last sensational year of judicial developments, with more to come in 2021. Keep track in regards to our assessments every month through Judicial Trends in Public Health. Charles, back over to you.
Thanks, James, and thank you everyone for your participation in today's webinar. And thank you all of our panelists for presenting today. Just a few final notes to all of our attendees. Attendees will be receiving an email from the network with the video playback of this webinar, as well as a link to our brief webinar survey. The survey takes just 1 minute to fill out and provides us with some really great insights. You'll also be receiving an email from ASLME with information on how to apply for CLE credits for this event. Finally, join us this Thursday for a webinar on the declarations of racism as a public health crisis. You can learn more about that webinar and register by going to networkforphl.org/webinars. That concludes today's webinar. Thank you all for attending and have a great rest of your day.